Mr. Bailey, would you mind elaborating on some of the specific findings so far from the Missouri versus Biden case that would just apply to the constitutionality of what I just addressed?
Absolutely. And first, let me say that there are numerous examples where President Biden himself, Vice President Kamala Harris, other officials with the White House, to include former Press Secretary Jen Psaki, have explicitly called for the repeal of Section 230 of the Communications Decency Act, which is a boon to social media corporations, an enormous financial benefit to these corporations if the corporations don't enhance their censorship policies. Then agents acting on behalf of the federal government go to social media and make more specific targeted requests of censorship. It is a relationship of coercion and collusion. It's not big tech acting on their own. That would be bad enough. But in this instance, as we've demonstrated through more than 1,400 numbered paragraphs of specific allegations backed up by evidence and documents that are available in our lawsuit, it's targeted, it's specific, and it's at the behest of the federal government. And as Rob Flaherty, the director of digital communications at the White House, opined, it goes all the way to the very top of the White House. It's grown so far that they need to establish additional bureaucratic structure to manage it. But the remedy for disfavored speech in this nation has always been counter speech, as you point out, not government censorship. In fact, government censorship is counterproductive to the public's pursuit of truth. The founders knew that. That's why they included it as the very first amendment in the United States Constitution. And I would also point out, as I've stated, that it's in times of crisis and emergency when we must be most vigilant in protecting those sacred and foundational rights.